Psychotherapy notes, process notes, progress notes, case notes. What is the difference? Hi, I'm Dr. Maelisa McCaffrey, founder of the free private practice paperwork crash course, and in this video, we are tackling the mystery of process notes, or psychotherapy notes, whichever term you use. Yes, psychotherapy notes are the same as process notes. And no, they are not the same as progress notes. Now, to explain the difference, we're going to have to dig into a little bit of psychology history here. Basically, back in the old days, when the predominant form of psychotherapy was psychoanalysis, the therapists at the time, usually called psychoanalysts, would commonly complete what we call process notes. Now, these notes were actual personal notes for the therapist themselves. They might include something like a conceptualization of the case, an idea of something they wanted to bring up to a client at a later time.
Notes to themselves so they don't forget something, transference, countertransference, etc., etc.
Over time, therapy evolved to include a variety of talk therapy methods. And with it, another thing evolved: the regulation of healthcare. Along came HIPAA, and it changed many of our lives. Okay, HIPAA didn't actually change as much as a lot of therapists would like to pretend that it did, but it is still an important regulation, and yes, we do have to follow it. Basically, HIPAA came along and provided guidance on accessibility to records, meaning who can and can't access someone's personal medical records. The HIPAA gods recognize that therapists, counselors, psychologists, psychiatrists, basically all the people who do psychotherapy, that we all take records a little bit differently. But they're tricky, and they didn't want to make things too easy on us, so they changed the name. What we colloquially would call process notes are referred to as psychotherapy notes in HIPAA. So I will use both of those terms interchangeably throughout this video. Psychotherapy notes, process notes, same thing. Regardless of what we call them, what the heck are these notes with this special designation per HIPAA? Quite frankly, process notes are whatever you want them to be. They could be drawings, genograms, notes to yourself, scribbles, shorthand, whatever. The most common way I see this used is when a therapist is just taking little brief notes to themselves throughout a session so that they don't forget important things. They're not viewing these little notes as their actual progress note or official note for the record. It's more for themselves. So that's a process note. These notes are very different from progress notes, which are also sometimes called case notes, because apparently we never want to pick just one term. Progress notes are the required notes that go in your client file. Progress notes are mandated by pretty much every state in the US, and they're ethically mandated by your professional association, every single one if you're in the US. They are meant to be in the client's official medical file and potentially shared for purposes of treatment, whereas process notes are for your own personal use and not meant to be shared. That's why the special designation for psychotherapy notes within HIPAA mandates that they be kept separate from the client's medical record or their case file. For example, if you use an EHR, an electronic health record, then most of them will have a separate designation for process notes somewhere else within the record so that it looks like it is separate from your regular progress note. And if you keep paper records, then you want to physically have them in a separate file. At this point, you might be thinking, if I have to write progress notes, but I don't have to write process notes, why are people writing process notes? Some therapists find them really helpful for conceptualizing cases, thinking through ideas, or writing especially personal information down. For example, I used to use what would be considered a process note to track names of family and friends for my clients. I didn't want to put all of those people's names in the progress notes for my client, but I have a bad memory and needed to write them down somewhere so that I could remember them. That way they were safe, secure, but they weren't something that needed to be released if my client's records ever needed to be released. I should mention here that process notes are not meant to hide clinical information that's relevant to your client's treatment. Now, there's obviously some gray area here, but a good rule of thumb is if it's necessary for your client's treatment, then it should go in a progress note. If it's clinically important, it likely goes in a progress note. However, if it's something you just feel like writing down and it's important to you, but would be kind of irrelevant to anyone else who came along to treat the client, then that could go in a process note. And this is why clients can't request access to your process notes. Well, I guess they could request it, but they're not considered part of the client's clinical record, so they don't inherently have the right to access those. They have a right to their personal treatment record, but not to your personal notes. This leads us to the number one biggest myth around process notes, and that is that your psychotherapy notes can't be subpoenaed. Yes, they absolutely can be. But before you have a reaction to this, let's think through it rationally. Almost anything can be subpoenaed, right? Any type of record. That doesn't mean it actually ends up in court. Usually, if your process notes were subpoenaed, it's because an attorney is just trying to grab at anything, any type of record or data that will help their case. They probably don't even know the difference between psychotherapy notes and progress notes, and they don't really care. They are just doing what is their due diligence to get all the information they might need for their case. Unfortunately, once a subpoena happens, you can't just ignore it, but that also doesn't mean that you just send everything right off. So remember when you had that first ethics class in grad school and you likely learned about client requests for records and subpoenas and this phrase called asserting privilege? Well, you're kind of going to do the same thing but for yourself. So you're not going to ignore the subpoena, but you are going to address it and request that your psychotherapy notes can be kept private. And most of the time, a judge is going to recognize that your personal process notes are irrelevant to the client's case and are not part of the client's medical record and are not necessary. Now let's be really clear here. I am not an attorney. I am not giving you any legal advice. And this type of thing can vary a little bit based on your state or county or whatever your jurisdiction. However, in general, you cannot ignore a subpoena. Do not ignore one, okay? And remember that judges and attorneys and all the legal personnel, they're just doing their job too. It's not anything personal, even though I know it does get stressful. Whew, okay, we covered a lot in this video. But what I really want you to remember is that process notes are optional. They're meant for your own personal use, and they're also not meant to hide clinically relevant information. That good clinical info should be in your progress notes. Okay, this video could be like a whole webinar training, so you probably still have questions. Please feel free, ask those questions in the comment section below. I will try to do some research and answer any questions that come up. Thanks for watching and happy writing!